Due diligence is an essential process for both buyer and seller to carry out before entering into any transaction. The investigative process is intended to reveal various upsides and red flags associated with the transaction. This vlog is intended to cover what due diligence means, what to expect, and why it's important. Due diligence is a broadly used term across multiple disciplines. From a corporate and legal perspective, it would involve an interested party carrying out an investigative process into the target company. It would also help negate against future losses or bad press post-completion of any deal. Due diligence starts when both parties have agreed to a deal in principle but haven't signed a binding agreement. It would usually start around the same time as entering into a letter of intent or heads of terms. So that's essentially a non-binding agreement setting out the basic terms of the deal. Aspects of the due diligence exercise would cover corporate matters, organizational structures, litigation, IP, real estate, among others. When assessing a company's corporate structure, one must have regard to the company's ownership structure, its ultimate beneficial owners, its subsidiaries, and any other affiliated companies that could have some bearing on the deal. When examining a company's contracts, you should put focus on the material contracts of that company, supplier contracts, consumer contracts, or otherwise. And in those contracts, you should have regard to certain clauses, for example, change of control clauses, which could potentially render the document terminated if there's a change in ownership of the company, or the duration of the contract, or the payment terms, and several other key material terms that are significant to the business that you're acquiring. Intellectual property rights form a substantial part of any company's assets. When acquiring a target, it's important to have regard to understand whether the IPR that's used by the company is either owned by it or licensed to it. If it's licensed, have a look at the licensing contract to ensure that it's intact and will remain to be active post-acquisition. Another key aspect of the due diligence exercise is having regard to any ongoing or threatened litigation. Litigation in a target company could have a serious impact on the price and value of the target you're seeking to acquire, and on any potential future liabilities that may occur post-completion. Labor and employment is an important part of the due diligence exercise. You see, when acquiring a company, if you're seeking to retain certain staff post-completion, it would be valuable to have insight into their employment contracts, ensure that you can in fact retain them, and whether you want to revise any of their ongoing employment obligations and terms. Similar to the IPR due diligence that you carry out, it's important to understand whether the company that's using real estate or land in fact owns the property or is leasing it. If it's leasing the real estate, it's important to have regard to the lease agreement, ensure that it's active and remains active post-completion. Due diligence is a painstaking process. The temptation can be to skim over certain areas to save on time and money. However, a thorough due diligence exercise can save you on long-term costs, bad surprises, and can hopefully lead to a successful M&A deal. Thank you for taking the time and tuning in. If there's anything Davidson & Co. can assist you with, please feel free to get in touch.